justice on behalf of all those people without being asked. And that is possible in a few European countries, but not by no means in all, which is regrettable, but we'll continue to fight for that right.
We've got another question from the internet. Going back to Facebook, what questions would you like Mark Zuckerberg to clarify this evening during his European Parliament hearing?
He's got a hearing in about an hour or so in the European Parliament. It was going to be closed, but I think it's open now. It will be broadcast.
I think that's a great question, and it's something that when Zuckerberg appeared in the US, we compiled a number of questions to ask him, and I think many of those remain unanswered and were avoided during questioning. So I think we could go back to those and really pick out the ones that remain, and many do remain about the way Facebook handles people's data. And really, going back to what we've talked about today, even one of those questions is actually, what's Facebook doing? Are they going to implement this dual standard, or are they not? That's something that there hasn't been kind of clear clarity on. But that's just one of the many questions that he should be answering.
And actually, all those questions are on the PI website, I think. We published them, haven't we? Yeah.
Hi, Anna, you mentioned earlier that there are some vague provisions in the GDPR that you anticipate more discussion and litigation to come up later. What are some of these that you anticipate will have more action on later that will be clarified? That makes sense.
So at the end of the GDPR process, when we analysed the final legislation, we identified some 52 articles in the legislation that gave some flexibility, leeway to member states to do their own thing. And that particularly applied to the public sector especially. And for example, we have seen a lot of those come through in, for example, the way the UK has proceeded with its own data protection bill, which does implement GDPR but has a lot of exceptions. For example, exceptions for political parties who are going to be allowed to process sensitive data like your political beliefs for the purposes of campaigning in elections. Another example, particularly bad example in the UK, was an exception for the Home Office for immigration purposes. It took away the rights from from the immigrants coming into the country. So those are the sort of general articles that gave a lot of leeway to member states. There were also a number of articles that were a bit vague. For example, automated decision making and profiling, which required guidelines from data protection authorities to actually interpret what this article means, and it generated a lot of controversy, and industry was again coming out in force and saying, no, it doesn't mean that, it means the other. The same happened with the consent provision to some extent. If you look on the Data Protection Authority's website, there's about 10 pages of guidelines explaining what consent actually means. And some of these articles will eventually be tested in the courts because they're not clear enough.
And I think that one thing GDPR is clear about is that it is supposed to be interpreted in a way that respects the essence of fundamental rights, respects the right to privacy, respects the right to data protection, and part of this difference in interpretation that's going to be played out is where trying to wind their way around the provisions using exemptions and loopholes to continue doing what they're doing with data and not actually taking that step back and reconsidering. I wanted to say as well a bit about kind of PI and that we, as we've been saying, have been following GDPR as it goes through, and we will continue to follow it. 25th of May is not kind of a deadline, it is just the start. And civil society are going to play a very important role going forward in being vigilant to the way that GDPR is implemented, monitoring that, and using it as a tool to both investigate and to hold to account those that are exploiting our data.
And that there is a big implementation campaign going on throughout Europe, done in partnership with many digital rights and privacy advocacy organizations, and they will be campaigning for the implementation of GDPR. And we are also working with colleagues in the US to persuade the industry there to implement the legislation, and no doubt PI will also be working with its partners globally on this. So there's lots more work still to do.
And we will be keeping kind of a constant update of what we're doing on that.
Technology is moving very fast. We see the increase in data-intensive industries, both in terms of new technologies, but also whole new sectors of the economy based on these things. Can GDPR cope with this rapid pace of change when our data may be used ways we didn't even conceive of when the legislation was drafted?
That's a very good question. GDPR is meant to be technology neutral. In other words, it has been conceived and devised to carry on for many years with the development of technology, because it's based on principles, on rights and obligations, not on specific technologies. But whether that will happen in reality remains to be seen. I don't know what you think.
The law is always accused of being behind technology and constantly struggling to catch up. But in the end of the day, that's not an argument to kind of just dispense with the law. So GDPR is a very important kind of step in the right direction, and it is an important tool and an important safeguard going forward. And so seeing how that plays out and that's implemented, but it is just kind of one part of a puzzle, like of a legislative puzzle and regulatory puzzle to protect the right to privacy. And we probably will see other efforts as well. So for example, in the EU, GDPR is not alone, it is accompanied by other legislation. For example, it should be accompanied by the e-privacy regulation, which is another law, which is about protecting privacy in electronic communications, and for example, when you're using websites.
And I think in the end, laws are only good as far as they are implemented and as far as they are enforced. And they are very necessary, but you also need lots of other measures. Like you need user-friendly technologies that people can use to safeguard themselves further. There needs to be like a whole ecosystem of privacy-friendly systems, including legislation and technology. And people invent lots of privacy intrusive technologies. We need more people to invent more privacy defending technologies as well.
And I think relegating data protection to just kind of a legal issue is a mistake. It is both a legal issue, but it's also like a design issue, a security issue, a communications issue, and all of those things. So it's important that it's not just kind of left to lawyers. And others know and understand it too.
Right? Well, if there are no more questions, we can conclude. And as Ailidh said, this is just the beginning of another stage. and I'm sure that privacy advocates will continue not only communicating about GDPR, but doing in-depth research to seeing how it is implemented by individual companies. So we conclude with that. It's not perfect, but it's the best we've got so far, and we'll make it work.